sometimes the people who want to be separated and finally divorced are stuck in a purgatory where their ex won't let them settle. Their ex won't let matters lie. And today we're going to be talking about 5 ways you can deal with post-separation abuse. Welcome, Mum.
Hello, Laura. Hi, everyone.
Now, today's topic is quite horrible. And I want to remind anybody that this may be triggering to anyone going through any kind of family violence, post-separation abuse included. If you need any assistance, please call 1-800-RESPECT or Lifeline, and you can check for any other emergency contact details in the show notes below. And also, you may notice I'm not looking particularly well. I'm feeling not great, but we know that some of you do hang on to listen to these episodes every week. So we wanted to make sure we got one out to you guys today. So please forgive me for my voice and my appearance, but we all do the best we can. So, Mum, let's just jump to the jingle and then we'll get straight into it.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
So, Mum, we've come up with these 5 ways to deal with post-separation abuse, and if anyone is listening today who is going through it, we have some really great episodes where we talk about the types of post-separation abuse. So you may be asking, am I suffering from post-separation abuse? Go and listen to those episodes. But Mum, can you give a little summary of what post-separation abuse is?
So post-separation abuse usually takes the form of coercive control or just constantly being in a person's face. Unwanted attention, unwanted contact. And the trouble with post-separation abuse is you can't leave and make it stop. It just goes on and on. And so, but the court has identified it. And a lot of the times people are using court cases, multiple court cases to control, coerce, and upset the other person.
But we're going to be talking about today how to protect yourself from the legal post-separation abuse. And there are multitudes of types of post-separation abuse. And we talk about the post-separation abuse wheel. Go and listen to that episode. I'll put that in the show notes. But today we're going to talk about how to protect yourself from that. Because unlike if you're divorcing a narcissist and they say, just block them on everything, it's kind of something you can't do if you are in the middle of a custody battle or if you're in the middle of trying to figure out your property settlement. And I've spoken to and met people who have been through post-separation abuse or still going through it for 7 years. It's the legal side of it that does seem to have a sting in its tail. And I do know there are many of you who are going through it at the moment where you know if you had a reasonable ex, you would have settled years ago. So let's get into it then, Mum. So let's talk about the first way. Number 1, you and you might have it there next to you. People need to know about the central practice directions.
They do, and I do. Of course I do. So your central practice direction is a guide to the courts or guide to the profession about how family law cases should go from now on. So the most recent iteration of it was in May of this year, 2024. And the court is setting up core principles there, and they are alive to the fact that people might be just using the court to bash around their ex using court systems. And in fact, I believe the Chief Justice has specifically talked about that in the past, that he's seeing people being dragged through by unscrupulous exes. So the central practice direction notes down or makes it clear in its core principles that someone who pursues court proceedings against somebody for no real valid reason is not only in breach of the central practice direction, but is setting themselves up for costs orders and so forth. So I'm very heartened that they have seen what has been happening, where I would think for the last 15 years.
And so the central practice direction is slightly different in WA, but it's all around Australia, and hopefully maybe in other countries that are listening, you have some sort of guidebook that the lawyers all use.
Yes.
that you can go and download and have a look at. So we'll put the link in the show notes for the central practice directions for everybody, being aware that WA is slightly different. But realistically, it puts the steps and expectations of behavior, etc. And Mum, you're constantly telling people, and I want anyone who's watching today, if you don't have a copy of the central practice directions and you're heading to court or doing mediation or negotiating with the lawyers or doing anything, if you don't have it and you're dealing with this post-separation abuse legally, it is literally a shield, isn't it, Mum?
It is, but it upsets me that it's been around for so long and some lawyers don't know about it. But when you draw their attention to the particular bit, it's not a huge document, it's 28 pages. You can read it, highlight the stuff that you think is relevant, point that out to the lawyer on the other side, or if you have to go to court, point it out to the court. And the aim of the core principles wasn't just to use them as a shield. The aim of the core principles, I say, with respect to the court, I think it was to stop people doing this behaviour in the first place. Of course, it's not going to have much impact on a litigant in person, but if they've got lawyers, this McCorrell highlighted copy, it's gold. And so you can send a copy of the core principles to your ex if it's going to put you in harm's way, or point out to the lawyer which section, and I would print it out, like put the bit in, that they are breaching by continually being used, I guess, against you.
So and we should just do a whole episode on it, to be fair. But sometimes in our Q&As with our members, they might say, oh, this lawyer wrote this letter to me and it said this and this and this. And you're like, send them a copy of the central practice directions and quote this. Can you give me an example of one of the things that you quote often to these kind of bullying, abuse, legal letters that people get?
For core principle number 2, right? There's 10 of them. It's the parties, lawyers, and the court's obligation and overarching purpose. And it just says that it says parties, lawyers, and the court's obligation. And they're supposed to, in one sentence really, the overarching purpose to be achieved is to facilitate the just resolution of disputes according to law and as quickly and as inexpensively and efficiently as possible. So that's it. That's your main, I reckon they've put as number 1 is risk, making sure they don't do anything that puts anyone at risk. And that's a blessing. And that includes don't take any of the steps that they tell you to take if doing so would put you at risk. We're more worried about the safety of people. But the lawyers are being hit with cost orders if they are being used as a blunt instrument by their client for unmeritorious claims.
What about the bullying letters? Is there one in there that you send for those that write a bullying abusive letters?
Well, I think the whole spirit of the central practice direction is helpful, but in particular, there's on page 3 of those central practice directions, number 1.4, and about 2/3 down, but the whole lot is very interesting. It says that ambit claims, in other words, asking for much more than you should get, should be avoided, and aggressive and unnecessary adversarial conduct will not be permitted and will not be tolerated. And that goes for lawyers as well as people in there. And at all stages in the proceeding, party must avoid filing evidence that is unnecessarily lengthy or of limited relevance to the issues in dispute, limit their number of witnesses, and so forth. But they say that cost consequences against parties or practitioners are possible, and I know in cases they have been made. So your lawyer or their lawyer may be made to pay the legal fees of the other person. And so the nub there, I think, Rose, is the aggressive correspondence. I think that's where a lot of people, we hear it all the time, don't we?
That's the trigger point.
And I think nasty people find nasty lawyers to represent them.
Mm. And I think it is important to note, and we do get a lot of emails letting us know how they're going in their court cases, etc., that just because these central practice directions exist and because this, and you said before, supposed to.
Yes.
And I guess, please don't shoot us as the messenger because we're saying this is what the court says it's supposed to happen, because we know it doesn't always happen. Yep. We know people get away with this kind of behaviour. We know that sometimes judges and judicial registrars and whatever may miss something or skip over it. Unfortunately, these things are happening and we are hearing from it on the coalface.
We
That
are.
this is not always legit what's happening. This is what they want to happen. So, Mum, to those people who are going through financial abuse, there are countless applications or countless mediations, and it's just never ending. You always say to them, don't give up, because at the trial, what happens?
Yeah. Don't feel that you'll never get your day, because at the trial, they will usually get their comeuppance unless it's been agreed outside the court. So when someone who has been committing post-separation abuse gets in the witness box and your lawyer starts to question them, their behaviour comes home to bite them in the bottom, mostly because I think people who are conducting post-separation abuse, that I don't think they realise that it is now a recognised form of family violence. It's, well, I didn't hit you. And it is one form of family violence, alas, that continues after you're separated, but therefore it's easy to prove. And they may, in the witness box, these types of people just come completely unstuck because they think they're off the hook because there's no bruises or whatever. But this sort of behaviour can be fed to them, and I've seen them come terribly unstuck, asked with the right questions.
So it's particularly those ones with really expensive lawyers, and we get these people writing, and they've got all these lawyers, they write these big fancy affidavits, they've had interim hearings, and it just all gets missed. We had another lady write in, she said the other day her lawyer didn't address all the false allegations because it was an interim hearing. But Mum, you constantly say it'll all come out. They give their full attention to this at the trial, which may or may not be any comfort to those who are going through it at the moment. But that is what we're seeing is happening. So let's get into number 2 of how to try and get out of post-separation abuse purgatory. And that is the magic section 117C.
Yes.
Now, can you explain what it is and how it can get you out of post-separation abuse?
So Section 117C of the Family Law Act talks about costs and who's going to pay costs. And one of the factors that the court looks at is, have there been reasonable offers made to the other person, which they have just blown off and not worried about? When it comes to costs at the end of the proceedings, if you can demonstrate that you've given them an offer that is the same as or even a better outcome for you than the offer, then you're able to say to the court, I wouldn't be here except this person has just dragged me through, and I made this offer months ago. And the court will consider whether or not to award costs to the other person. And now they've always had, but they've got more power to award it against the lawyer.
So in other words, basically, it's a big red warning sign to your ex. I'm making a reasonable offer. If you don't accept it, their lawyer is going to have to say, look, if you don't accept this, there is possibility you will have to pay their legal fees.
As well.
Now,
as well as your own. Well. And if you don't get usually you're asked to pay the legal fees because you didn't get what you wanted. And so you end up with not what you wanted, and you have to pay your own legal fees and a good whack off the other person's legal fees, and sometimes all of the other person's legal fees.
Right. So it's kind of a way of waking them up maybe to saying, hey, your behaviour is going to be checked. And we do hear a lot that, particularly in manipulative, controlling and narcissistic types, when negotiating, they move the goalpost.
Yes.
So they might say, I'll only agree to 60-40. And then maybe you're just desperate, you want to settle, you give in, you go, okay, 60-40, here's my offer, 60-40. But then because they don't want to stop it, the financial abuse or the legal abuse or the post-separation abuse, they go, oh, no, they gave in. Okay, it's like 70-30, right. So they move the goalposts. So this is, I guess, a way of kind of locking it in and going, you know what, if I am going to have to suffer through this, if I am going to have to go through all this pain of court, potentially and hopefully at the end, I can get some financial back from that, or it may make them think about it. Now, you have to make an official offer though, don't you, Mum? You can't just be writing letters back and forth.
No, you can be writing letters backwards and forwards, but I always say the best practice is to keep the offer on a page of its own, in a letter or email of its own, so that when you want to show it to the court so that you can get your costs, It doesn't get lost in a sea of other things where you've been talking about furniture or cars or whatever. So you might write that letter and say, and here is an open offer attached here too, and then you do. And I always also attach to the letter or to the email as part of the document a copy of Section 117C of the Family Law Act, so that even if their lawyer isn't worried, because they're going to get paid anyway, your ex might look at that and go, oh, whoa, really? I could be up for both. And it hopefully changes their minds, you know. Mm. See, Laura, can I just say one thing? When you talk about those brief interim hearings, it's a bit of an issue, because if we don't have quick interim hearings, the judges are tied up with long-winded cases, and when they could have been applying that time to someone else's final orders. So it's just a kind of a triaging process, and trying to make sure that the judicial registrars and registrars do enough and the judges do just enough at the interim stages to keep the case rolling through to the end.
Okay, well, let's get on to step 3 of things you can do to get out of legal abuse and post-separation abuse purgatory. And we see this all the time, potentially if you've got an avoidant ex or a manipulative controlling, and maybe you can't even get them to go to mediation. Maybe you can't even get them to do disclosure. And they just like, nah, I'm not going to do any of it. I'm going to just make you suffer for as long as possible. So what kind of things can people do? And what is this number 3, the big scary one?
Go to court. Yeah. So going to court involves a few preliminary steps that don't require the cooperation of your ex. And in fact, it's good if they're not going to support what you're offering the mediation, and you give them a notice of intention to file and make a genuine offer. And if they don't respond or respond in a silly way, then I think you don't waste too much more time doing that. Get the matter started in court. Yes, court's expensive, and it is, you're on that conveyor belt once you file. But the good thing is, so are they. And then you might get some action against them. The court is tightening up its procedures for people who don't give disclosure, for instance. And when a court makes an order, and that includes the registrar, judicial registrar, judges, to file a document or to give someone a document by a certain date, and the person doesn't do it, the court's pretty quick. It's like in a classroom where the teachers suddenly had enough, and they take those kids and send them to the defaulters list. And the defaulters list is where the bad people go to get their hide tan by the judge or by the person who's in charge of the defaulters list. And the ultimate outcome might be that they are not allowed to participate in the final hearing, and that you get the floor. You do have to get both sides of the stories, but they've got a lot to lose. Yeah.
Now, that's an ideal scenario. And before you even consider going to court, go and see a lawyer, because every situation is different. And we have got an episode on how to divorce the statute, where you can divorce and get your property settlement and all of that done, even if your ex is in a different country or has just gone AWOL, gone bush. And we talk about some really interesting cases that you've had over the years or heard of over the years. Go and listen to that episode if this is your situation. But basically, the other thing I wanted to point out from what you just said, Mum, is it's probably, again, we are getting a lot of messages saying the judge didn't care that they hadn't done their disclosure. And again, the disclaimer there is the judge will care if they haven't done their disclosure by trial, but sometimes they let it slide, it would appear to some people. But other people, they don't let it slide. So it really does depend who you get on the day.
It does. And some judges will hit a person for costs. If you had to go to court, you get into court and you go, I haven't got any disclosure from this person. The judge swivels their eyes to that person, and if you apply for costs, you may get some reimbursement for that. So I know it's in an ideal world. In an ideal world, the judge would they would all just follow those steps, and they have all those options, and they would take the one that's more favourable to you. But judges have discretion. It's always at their discretion. They're not required to issue cost orders. And sometimes I think a judicial officer is careful to not make one person feel like they've had a win too much if they're hoping that ultimately all will settle. Years ago, have I got time to do one of my reminiscences?
Go on.
years ago, we were not allowed to file an affidavit. It was just your application and financial statement for property and just your application. It was felt that filing an affidavit, once those words were on paper and the other person's read it, that's probably the end of their relationship going forward, or any last minute kindness they felt towards one another has just disappeared. So I think it's like that. I think that they're trying to, they're going to use a little bit of carrot, a little bit of stick.
So it's like good cop, bad cop kind of thing. And if you get to trial, then it is really bad cop. Yeah. But before that,
they don't care. Once it gets to trial, the court says, well, you're here now. You can't sort it. I'll sort it.
And we did an episode called Reasons People Don't Settle. You can go and listen to that to get maybe into the head of your ex. And you do say, look, one of the ways is go to court. And sometimes, as you've already mentioned, sending them a notice of intent to go to court can maybe give them a little bit of a kick up the bum.
Yeah, that's right. So that's one of the practice directions that we must do. And it's 2 weeks before you give them 2 weeks notice. And what is meant to be quite chilling about it, right? And I think it's meant to be quite chilling and also make you focus, remind is the orders have to be the actual orders that you're going to be seeking. And so it's I think it's like parenting or in a classroom. You've got all these options, and then at some point you're like, that's it, I've had enough. This is your last warning. And that gives you two weeks. And unless they make a genuine attempt to negotiate with that, then you go to court. Even if they just write something snarky back, you should probably go to court. But
if you've seen a lawyer.
But sometimes it brings them to the negotiating table.
And just in case anyone's interested, the going to court is basically an initiating application most of the time. We've done an episode on responding to an initiating application. Go and listen to that so you can get your head around the paperwork that's involved. You can do it on your own. Yeah. It's better to do it with a lawyer. We recommend you see a lawyer before you go to court because you don't know what you don't know.
That's right.
There are community legal, there's legal aid, there's plenty of lawyers that will help you for an hour session. So make sure you go do that. Now let's get on to number 4.
Okay.
So when people are going through this legal abuse where the ex is just not going to settle, they're being pains in the butts, they want this to continue, protecting yourself from post-separation abuse, purgatory.
Yes.
And this is relatively new. I know it had a different name in the past, but these new changes come through, and it's called a harmful proceeding order.
You're invited to our free webinar. Whether you're stuck at the beginning of deciding to divorce or you're struggling to find your way through the legal jargon and fear of the unknown of the legal process, we are here to empower you to take control. Join us to learn what steps you can take, followed by a live Q&A where you get Lynn, my amazing mum, and family law accredited specialist to answer your questions. All you have to do is go to www.thedivorcecourse.com.au and click on Reserve My Seat. We'll see you there. Hurry, spaces are limited, so don't miss out. Register today.
And this is relatively new. I know it had a different name in the past, but these new changes come through, and it's called a harmful.
Yes, so it used to be vexatious litigant, which of course no human understands. So
it sounds like some sort of disease.
It does like a disease a cow would get.
Yes.
So,
which is accurate, really, when you think about it.
So the harmful proceedings is the new thing in the Family Law Amendment Act of 6th of May. They're much more specific about what the court's looking for, and the court has the power to make it without someone applying for it. But if you ask for it, you may get it, you may not get it. But it is certainly something that allows the judge, I would think, if they're close to the line and they're thinking, geez, you're nearly at that point where I have to make that order about you, but I'll give you one more chance, sort of that sort of thing. So there's no harm in asking. It's like asking for costs. Okay. If they do get listed or ordered, or they get labelled a harmful proceedings vexatious litigant type of person, then, and this is rare, but it happens, they can't file anything without it going past a registrar, and they are not to serve anything on you, and the court will usually reject it. So I was once in a really hard matter, and I got served as their lawyer with 6 applications on Christmas Eve. That was when I used to open. And I missed one of them. When we came back, 12th of January, there was, and I'd missed one or two. I mentioned something to the court associate and she said, you should see the ones we don't let him file. So they just turned their hatred on me. And so the court can act as quite a good shield. You will never know if they've been labelled a harmful litigant. Then what the court is trying to do is make it that you're blissfully unaware that they're still trying to do stuff. Look, there's 2 aspects of that. One is your health and your safety and your mental safety and family violence. The other is that the kids, it's generally accepted that children are better off if their parents aren't going through the court. So it's part of the court's plan to keep you out of court at the beginning and make sure you don't come back to court. Like they're trying to bookend it. I do think that it seems to be working and people are getting through the whole process a lot quicker than they used to.
Did a TikTok, Instagram, whatever reel about the new harmful proceedings order that was brought in, and I did a little explanation of it. And holy moly, did I get some, that didn't happen to me. And look, I just know that people will be listening to this going, but why hasn't it happened to me? So don't give up hope that I think they really say these harmful proceeding orders for the ones that have been in court.
Absolutely.
Yes. And usually ones that have already got final orders.
Well,
is that right?
It's often, the final orders, it is. And the reason is because that it's a public service available to us. It's a public opportunity for us to resolve our disputes through the court. So they don't make those orders lightly. For any comfort for people who think that the court's just letting that go through to the keeper, at the final hearing, when all of the behaviours come out, the court has a discretion about how much you should be awarded by way of, say, property settlement or time with the children. And that conduct in court, the conduct of the proceedings is one of the factors for a costs order against them. And also, I'm sure it plays into the court's mind when they've got, say, a 10% range that they could give that person. They might lean more towards giving them less than more, you know what I mean, because of their conduct of the proceedings.
And I see the barrier again because it always comes down to final trials. And I can see the frustration because sometimes people are waiting a year for trial or, 2 years for trial. So it is really frustrating for some people going through this abuse to go, oh, well, that's great. I've got to endure this for another 2 years. So I think, Mum, would it help if it is legal abuse? If they could lay out, if there's interim hearings on, many things, just dot point every time their ex is filed and every time it's been dismissed or every time they've taken it to court and it's been slapped back. If you did a dot point list for these people that maybe are listening who've been at court for 3 years or 4 years, they did a dot point mini timeline in their affidavit.
And yes, because the courts are moving, or I think most of them have moved completely onto the computers. You'll see they're online. But when one looks at the orders, and I don't know what the judges get to see, but when you're on the portal, the order dates are there, but you don't really know what the outcome was. And so you can cut and paste from the orders or off the portal, that list of orders, put it into your own timeline, and then put in after each order what the orders were, like in 1, 2, 3 or dot point. So there's a handy thing for the judge to look at. And if it makes a table, if it's in a blooming table, then the court can immediately grasp how hard this has been and how frequent this person's been mucking around. Otherwise, because we go from registrar to judicial registrar to judge, there's a risk that one person might be aware, but when it goes to the next person, they just think that your ex is a normal human.
So they may just be dealing with the immediate issue at hand and taking it on face value. So if they've filed something saying whatever it is, and it seems like a really bad thing, and that person's in front of a judge or a judicial registrar for a really bad thing that they've been accused of, if they've got no context to say, oh, this person has also filed 27 other times for really bad things and they've all been dismissed, they can see it in a different lens and they will probably treat it differently.
I agree.
But if you go in without that context behind you at those mini hearings and those mini appearances, you may find that it gets missed. So just that it potentially is a way to just kind of be like this without even having a harmful proceedings order. You can just kind of have it there as like quotation marks. Look at the crap I've been put through.
Separation abuse. Yeah.
And we've seen the new handbooks that are going out to all the states. Sadly, some of them have been out and about since 2022.
Wow.
But these are bench books that the judicial registrars and et cetera look at. And they have in their coercive control. They have in their legal abuse. They point all this sort of stuff out to them. But I don't know if it's coming across. So you really do have to, don't say my ex is a narcissist. Don't say my ex is doing legal abuse. Just show it through facts in a little table or a little summary, and that may help you on your way to a harmful proceeding.
Like my old pupil master used to say when I was at the bar, he'd say, you've got to put the breadcrumbs in to help the judge get to the answer you want. So you can't say to a judge, I would like you to order him to not do any more, or I'd like you to order her or label her as a harmful litigant, if you haven't given them the reason to. And the biggest worry, I think, for judicial officers, at least it would be for me, would be being appealed. So they're being told and they're being talked about coercive control, whatever their personal views are about it, and the judge does have a discretion. But if it comes out the wrong way and they are ignoring or not applying the new spirit of the Act or legal parts of the Act, it's possible that on an appeal, the appeal court will make those findings and overturn the order. So although the judiciary is independent, they follow the Family Law Act, they interpret the Family Law Act, and that Family Law Act comes from the government. So with the separation of powers, the government was on board. Some of the judges are on board, but they're being trained how to work with this, and they're making lawyers come to grips with it all, which is wonderful, through the central practice direction. And I think through all of those processes, and you being just the meat and the grinder, though, I'm afraid, it should become more accepted. Okay?
Just like women wearing pants to court.
Well,
which what year was that?
It was 95, 96.
Yep. There we go.
And
so
the judge
court
would
will
not
catch
listen
up.
to them. Would not listen to her.
Yes, so the court will catch up. They're just a bit slow because every woman was wearing pants in 1990. Anyway, all right.
It's the slow wheel, Rose. So it doesn't rush. Law doesn't rush. It develops.
Yeah, I know. But I know it's frustrating for people. I can feel the frustration oozing out of the computer as we record this.
Oh, I feel guilty.
I want to grab you all and give you the biggest hug because holy crap, does being in post-separation abuse purgatory sound like a horrible situation? Oh. Now, lastly, last thing they can do, and I'm sure there's many other things they can do, but number 5 that we've put today is build a fence.
Yeah, build a fence. Build a metaphorical pretend fence. And don't put it around you, put it around them and the court proceedings, right?
And label it zoo.
So you've got all of your life to roam around in, but that crap, that stuff that they keep sending you, don't give them the satisfaction of it offending you or upsetting you. So limit the time that you'll look at it. Send it all straight through to your files and wait until you're on the phone to your mother or someone you love, or till you've got your chocolate and your cup of tea, whatever. And then open it all in one go. You can't sometimes do that if you're like in litigation and you might have to do something in a very short time, but try not to jump each time a message comes through.
Yeah. Respond, don't react.
Yes.
And observe, don't absorb. And I think if you pretend every time you're reading one of these legal letters or some sort of whatever post-separation abuse crap they're going to throw at you, put on your science coat. Like literally just go, okay, I'm going to read this and I'm putting on my science coat and look at it from a scientific perspective of this interesting specimen of a human who is trying their hardest to make someone upset and cause them angst. And like you said, Mum, that person that was sending applications 2 days before Christmas, We've heard of them sending it on their birthdays, on their wedding anniversaries, or the day they're getting married. So there's so many ways that these people want to get into. So put on your science coat and go, oh, I wonder what tactic and weird behavior this psychological experiment person is going to do today. Oh, look, they're trying to upset me through sending it to me on this day. Oh, look, they're trying to upset me because they've mentioned, I don't know, my grandmother. So look at it from an outside looking in. And I know that is ridiculously hard to do. And Mum used to get so upset with me sometimes because I would go off. I'd be so upset sometimes. And you go, don't let it upset you. And I would try my best, but sometimes I can't. So if you know it's going to upset you, if you know no matter what you do, it is going to upset you, choose when your upset is going to be.
Yes.
If you've got, I don't know, a school performance to attend, don't read their message before you go. Wait until you've had your fun time, you've lived your fun, you've had your happiness, then read the poop, So choose when. If you can't, let it not bother you. But putting on your science coat and looking at them like a special science experiment. And I think in some ways that's all you can do because you can't for a while stop it because they are in the system. That assumes everybody's in the system for a valid and real reason. I guess they can't just randomly refuse people to use the court system without valid reason.
That's right.
So unfortunately, these people exist. Unfortunately, by the sounds of if you're listening to this, that is your ex. But if you can build a fence, like Mum said, and make it them that's contained,
yes.
If you can't not get upset about it, choose when you're going to get upset. And don't let it ruin your other happiness because you can't I know we say you've got to put your spending on hold for some extent. You've got to put your lifestyle level on hold, but you can't put your life on hold.
Yes.
And you don't want to not have happiness ever again. Right. And you're going to find glimmers of happiness even in your darkest weeks and months. So don't let them ruin your glimmers of happiness.
Because you're not still with them, which could be worse. Laura, I was reminded about our word salad episode then. Yes. Put your chef's hat on.
Yeah. So if you want to go listen to the word salad episode, it's how to read a letter like a lawyer. And it's our little 7-step strategy. And you take the steps before you and after you read the letter on how to go through it. And that is the same kind of thing. You're just being a bit more scientific about it and taking the emotion out. We've got a checklist for that. If you're interested, you can just comment below and I'll send you the link, or you can go and find it on our website, thedivorcecourse.com.au. We've got plenty of free resources there for you. But look, we can't fix your legal abuse. We can't fix the family court system with some of the issues that people are facing. And we definitely can't fix your ex. But what we can do is be there for support. And we can provide you some strategies. So go and download the Central Practice Directions today. Go and find what Section 117C is. Go and listen to that episode. Look up court stuff. See if that's something that you can consider. Go and see a lawyer. Learn about the harmful proceedings order and definitely build that fence.
Yes, I think that's absolutely right. And if this has been helpful for you, or if you found any of our ones helpful, we'd love it. I'd love it if you would subscribe so that people who haven't found us yet can get some company through this rubbish time of their lives with us.
Yes.
Thank you.
And I think in saying that, Mum, we should probably read a review.
Right.
So thank you. We've received a not very nice one recently. Also, thank you. We love feedback, but we have a differing opinion to that person. Mum, you were wondering if we should do an a-hole of the week. But no, we won't be doing that. But let's read this beautiful comment that we received 9 days ago from, I'm not going to read her name from YouTube, but it does. I'm going to use the initials MH509. So you'll know who you are. And you can email us at thedivorcecourspodcast@gmail.com to get a free chat with Mum. So it says, I just came here to say what a gift you ladies are to anyone navigating their way through the family court system. Even though I'm living by the third lot of final orders.
Yeah.
It's crazy. And have spent the last 10 years in the family court system. Oh, that makes me want to vomit. You poor sausage.
Cool, babe.
I still really enjoy watching each episode on YouTube. Thank you for approaching every topic with care and understanding. You are so welcome, Em. And hopefully you can have a chat with Mum. Maybe she can see something that hasn't been seen yet. But final orders 3 times and 10 years in the family court. I hope this episode has been some kind of help to you. But thank you to those people who write reviews and comments. It gets our name out there. It gets more people listening to it and gets the help to people that need it. So, Mum, thank you for sharing all your wisdom and knowledge. Thank you, everybody who has rated or reviewed or subscribed. So thank you, Mum, and thank you, everyone who's written a lovely comment or review. Please continue to do that. If you want to reach out to us to give us any ideas for episodes, you can do that in the comment section of YouTube as well, or email us at thedivorcecourspodcast@gmail.com. And go to our website. I don't talk about it enough. We have a blog page. I need to change the name of it, but you can go in there and it has pretty much a large portion of the episodes we've done. You can type in the topic you're looking for and it will bring up the relevant episodes for you. And that way, if I'm aware that we've got like 70 something, nearly 180, and I don't think I numbered them properly at the start. So, close to 200 probably. But if you want to go search through them to find the relevant ones for you, go and use thedivorcecourse.com.au/blog. And then you can just search there for the episodes that are relevant to you. So thank you again, Mum, for your time. And thank you, everybody, for listening. And we'll see you again next.
All the best, my dears. Bye-bye.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.